Please hold. Test. Let's check the stream. Test. One more time. Latency is a lot better than compared to yesterday. I think it sounds a lot better. Let me check on my phone and get started. Gonna do a repeat of yesterday, just from the fact that it could have been a little bit more clear. So, let's get started. It's not what I want. Trying to get my blacks. There we go. I already had it pulled up. There you go. Any day now. Please hold. There we go. Alrighty. Greetings, peace to everyone watching this. I pray that this finds you well. Before we get started, I'd just like to let you know, this is not legal advice. We do not offer legal advice. If you are seeking legal advice, please seek out a registered and competent attorney at law. This is for educational and entertainment purposes only. Reviewing today, Weiss's Concise Trustee Handbook, a guide to the administration of an express trust under the common law, functioning under the general law merchant. Alongside with that, we're going to be looking at a couple of definitions in Black's Law Dictionary side by side, so you can get, so we can get a fuller, better understanding of what exactly is being said through this document. I'm excited to do this. It's going to help continue to further my own understanding, but also help other people who are coming to realize how to operate in a particular manner, what the best road is going to look like in terms of that. So with that being said, let's go ahead and hop into it. If you have any questions, please feel free. I'm going to try to make sure I go through this as efficiently and clearly as possible. So this might end up being 4 parts. It might end up being 7 parts. I just want to make sure the information is readily available and interpreted in a way that even a child could read through this, watch this video, and understand it. So with that being said, let's get into it. So the introduction. This handbook is about the administration of express trust created under the original American common law and functioning within the unique system of commerce in the American states, i.e. the general law merchant, as it stands in the 21st century. So when we talk about general law merchant, we're talking about commerce. We're talking about buying and selling, purchasing assets, things of the like, if that makes sense. Transfer, all of these things. As the footnote, and I'm going to make sure I go really in depth about these footnotes. The general law merchant is embraced under the general common law, the original and unique system of commercial law in the American states, in which there is no commerce regulation of express trust, except, he spelled except wrong, except in connection with income derived from corporate stock and physical franchises, under Article 1, Section 8, Clause 1 and 3 of the Constitution. So basically what that is saying is, there is no regulation of a private express trust until the private express trust decides that it wants to get involved with affairs that are underneath the the commercial law, which is now referred to today as UCC, General Law Merchant Commerce, UCC, Uniform Commercial Code. That is what that is referring to. The material presented herein has been reduced from various sources, which the reader is encouraged to examine for his own knowledge and further understanding. The material herein has been rendered into a concise handbook format, intended to allow the reader to refer to each section for guidance on decisions regarding the most pertinent aspects of the administration of an express trust. So only secondary attention has been given to all other matters. So you'll see here in the intro, it'll be talking about some things like implied trust. We'll cover it, but the goal is to understand how a private express trust operates, if that makes sense. So, continuing. All in all, the author's objective by this handbook is to devise a simple guide with clearly outlined methods and sample forms for the effective handling of affairs of express trust, while also showing the many options for growth and prosperity and profound protections afforded by express trust when created and administered properly. This book is written in a somewhat unconventional manner in order to accommodate this objective. So you'll see it'll hop around from topic to topic, go back to topics at certain points, but that is only to essentially give you a better understanding and further the understanding that may have been laid before, if that makes sense. If the reader should, and this is important right here, and this next section goes for me as well, especially for me. If the reader should find, after examining the sources, or the narrator, that this work has failed in its objective, then let it be attributed to a fault of the author, not to any supposed faultiness of the sources of the express or the express trust itself. It will be admitted by all honest and learned lawyers, as it once was when the lawyer by definition was learned in the law, that the express trust, especially one created with proper care to its instruments, is a far superior form of security or organization in general for individuals who desire to exercise their natural rights. And a little footnote here talking about lawyers. It was the strongly held belief of the United States Supreme Court Chief Justice Warren E. Burger that 75 to 90% of all trial lawyers are either incompetent, dishonest, or both. No comment. No offer legal advice here. Trust basics. First, it must be understood that any trust, regardless of the many designations applied to them, is in its most basic sense a property interest held by one person, the trustee, at the request of another, the settlor, or can be referred to as the grantor or the creator, for the benefit of a third party, the beneficiary. Benefit, beneficiary. Make sure you tie those two terms together. And there's a footnote here down at the bottom about the beneficiary, Black's Law Dictionary. An even more basic definition is provided therein as the right enforceable solely in equity to the beneficial enjoyment of property to which another person holds the legal title. There are more sub-definitions as well as expansions upon the nature of a trust relationship being a fiduciary one. We won't get into them for want of space. So I'm going to cover that really quickly. So as you look here, you see, let me just finish the paragraph. The classification applied to a trust is based primarily upon its mode of creation, in which it may be created either by act of a party or by operation of the law. In the case of the former, trusts are divided into two types, express or implied. So when we decide to create a trust, before we even get to the active, obviously we have the active party, but there's three parties. Trust in its simplest form is a contract. And that is so important to understand because Article 1, Section 10 of the Constitution for the United States, and we're going to talk about that. I'm going to read on that here in a little bit, but you're fully protected when your express trust is structured appropriately as according to its terms and conditions or its declaration, which we're going to cover. There are three parties: the creator / grantor / settlor, exchanger, etc., etc. These are the people that have the property initially, full ownership of this property, and they want to convey it by means of barter, sell, purchase, or not purchase, but barter, sell, there's another one I'm forgetting, there's a technical term for it, actually, no, I completely misspoke. Sorry about that. I'm going off on another tangent. My apologies. See, if there's any mistake that I made, attribute it to me and not to the Private Express Trust or the trust law that has been well established in this country. So the exchanger / grantor / settlor previously purchased or bartered for the property, but they're taking that full ownership of that property and placing it in the possession or trusting a trustee to handle and manage this property. A trustee is a simple word for a manager, essentially. You hold the title to the property, but you don't have ownership, if that makes sense. And they hold that property, manage that property for the benefit of a third party, which is the beneficiary. So let's continue. Sorry about that mistake. Let's see. So without getting into the various subclasses of express and implied trust, the basic difference between one created by express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions, so presented for want of space, since there are many intricacies concerning the true meaning of the term implied. So basically, an implied trust comes from it comes from, I guess you could say, an act of the law. And there are a lot of constructive trusts today that a lot of people don't realize are actually there. It has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust, which is the Declaration of Trust, or the terms and conditions, to simplify it. So we won't get into that. Our focus is on a particular written express trust type, and even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protections of the common law. So we don't need to know. You should do your research on implied trust because it's going to help you understand a lot better how we are operating in commerce today to a certain degree. But again, our focus is on the private express trust. So let me go back. So you have, when you create a trust, when we're going to look at the express trust here. So obviously we have our grantor, who then creates a declaration of trust and has the trustee read over and agree to it, and then they transfer the title and the property for management to that trustee for the benefit of a beneficiary. This can be done orally. The reason why you want to stay away from that is because if for some reason something goes off the rails in your affairs of trust property, someone can apply to a court of equity to seek remedy. And if your terms are not written out in the appropriate manner with the appropriate language, or if the language is in those terms and conditions are statutory in nature, you're putting yourself in harm's way either way. So I just want to make sure I clarified on that. Express trust under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition. Let's zoom in for you guys. By Alfred D. Chandler, Esquire, 6. Which he says, that's just a little footnote, we'll keep going. In a report submitted to the tax commissioners of Massachusetts on unincorporated associations, I'll get to that footnote after I read this definition. His study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, pages 6 and 7, he offers the following definition. And before I read this definition, understand that what the context. So whenever you're studying anything, whether it be trust, whether it be law, whether it be UCC, whether it be scripture, whether it be any source material, anything, always try to gather a context, historical context, situational context about what's going on. In 1911, there was no income tax. The real people at the time were operating in commerce with lawful money and not legal tender, and we'll cover that a little bit here later, probably in the second or third part. But I just want to help you understand, like, times were a lot different. So this is the definition that was offered. Express trust put the legal estate entirely in one or more persons, while others have a beneficial interest. Interest is just another word for right. So anytime you see interest, we're talking about rights. Others have a beneficial interest or right in and out of the same, but are neither partners nor agents. This simple, adequate, common law right any person or group of persons sui juris may exercise. The trustees issuing certificates of beneficial and capital interest rights divided into shares, as well as issuing bonds and other obligations, as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. So when we talk about sui juris, that is natural right. That is of one's own right. Understand this, and this is a huge distinction to make. When people assert their rights, they talk about, well, the Constitution gave me my rights. The Constitution gives me this right. The Constitution does not give you any rights. I'll say that again. The Constitution does not give you any rights. It secures and protects them and holds people who try to infringe upon those rights accountable. But your rights don't come from the Constitution. They come from your Creator. So when we look at trust, I explain the structure of a trust. I want to stop here really quickly and explain this because it's important. Let's look at from the beginning. If you believe, whether you believe in the Most High, God, or you believe in a presence, bear with me here. So let's just say the beginning. There was the Creator of heaven and earth. He is the grantor. He's the creator. He's the settler. He has the property. The property is his. After that, what did he do? He created man, Adam. What he did is he said, okay, I created this, Adam. Now you have dominion over this. Here's your terms and conditions. You can eat from all of these things, just do not eat from this tree. You can have this, you can have that, you can have this, you can have that, but don't take from that tree. Adam was the trustee who received property to manage from our Creator. For the benefit, I should say, of the offspring that were to come from Adam, if that makes sense. When the Creator, our Father, made specific terms and conditions, that was a trust, declaration of trust, terms and conditions of a contract, etc., etc. So remember, a trust is a contract. When Adam broke those terms, he became liable, and Adam died, as we know. He became liable, and he was expelled from the Garden of Eden. It's the same exact thing with any trust. So that hopefully that paints a little bit better picture of what this may look like. A lot of people want to complicate the matter, but we want to try to break this down to its root form, if that makes sense. Because Adam was supposed to follow these. He was given the earth and to follow the instructions regarding it for the benefit of everyone that was to come after him that was going to follow the instructions as well. So let's continue. Because I already read that. Yeah, sui juris, this is fine as of his own right, not under any legal disability. And we'll talk about legal and lawful. Legal and lawful are two different things, and we'll get to that here in a little bit. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another like any basic trust. It's that, but it's much more than that. Rather, it is a trust created by a private contract for the holding of a divisible property interest, wherein the trustee is empowered by the creator or grantor or settler to do for a beneficiary of the trustee's choosing, whatever he may do for himself as an individual of his own right, sui juris. What has been created here is a trust organization, lawful by natural right, sui juris, as a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Doing so requires no benefit, no privilege or franchise from any government or other outside party, and therefore the parties owe no duty to any government or other outside party to the extent that no common law, criminal or civil wrong is the purpose of the contract. So let's stop there. We got a couple footnotes that we went over. Footnote number 10, it says, a person who creates a trust may mold it into whatever form he pleases. Footnote 11, let's see if we got anything else. It's before I go on to Hale versus Hinkle, understand this, and this is why this is so important, because a lot of people are thinking, oh, this stuff is taboo, I don't know if this is right, I want to do this, I want to do that, but it just seems very conspiracy-like. To each is his own. This is not legal advice. This is entertainment, and informational and educational purposes only. You have to understand something about the structure of, everyone wants to say their system is broken. That is an ignorant comment. Excuse the connotation of the word ignorant, but it is an ignorant comment. It's not the system that is broken. It's the understanding of the system that is broken within people. I'll say that again. It's the understanding of the system within people that is broken. The system is the system. It's all based off of contracting your rights away, and trust law. So when we talk about here in the footnote number 10, Harwood versus Tracy, we're talking about Supreme Court rulings. What is a Supreme Court ruling? A United States Supreme Court ruling is mandatory authority. A ruling by the Nevada Supreme Court is mandatory authority. A ruling by the Kentucky Supreme Court is mandatory on Kentucky, just like the one in Nevada is mandatory in Nevada. But the United States Supreme Court is the highest court, and all of their powers of the courts underneath them derive their powers from them, if that makes sense to a degree. So what does that mean? That means that whatever the Supreme Court of the United States rules on, that is a binding effect on all lower courts. Now, will all lower courts follow that? No, you have to put them on notice. And even then, sometimes they might not, but you have to go to the appeals to get your remedy. But with that being said, this shows that this mandatory authority, this has this binding effect of trust law being settled. And if it's saying a person who creates a trust may mold it into whatever form he pleases, especially going back up here, of their natural right, of your own right, of your common law right, as long as there's no common law, criminal, or civil wrong being done, you can do whatever you want, as long as you're not violating this simple foundation right there, if that makes sense. I wanted to explain that because a lot of people think this is taboo, this and that. It's not taboo. The government themselves have said it. They said it. It's just up to you to assert that. So let's continue. Footnote verses 11, I should say. Hale versus Hinkle. This is probably the most monumental. I'll probably do a whole nother step. I don't want to take up too much time here. Let me see where we're at right now. We're about 5 minutes in. I was going to say, no way. 23 minutes in, so I'm halfway through. So Hale versus Hinkle is probably one of the most foundational and important Supreme Court rulings ever. I'll probably do a read-through of that ruling in and of itself. So I just want to make sure you guys, if you have time to read that on your own, please do so. But continuing. When done properly, the trust is afforded all the common law protections ordinarily given to private contracts, particularly the obligation of them. Footnote 13. This is important. Please pay attention to this before I continue. Because here we go. More Supreme Court law based off of trust. Supreme Court rulings in regards to trust. Berry versus McCourt. The court held that the express trust is a contractual relationship based on trust form. And in Smith versus Morse, it was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is therefore violative or in violation of Article 1, Section 10 of the Constitution. So going back to the example that I knew I forgot a point, going back to the example of how I said our Father is the creator of the trust. Adam was the first trustee, and then we as derivatives were beneficiaries, but then we're also now trustees when we step into that role at some point. Adam got his rights from the trust, the declaration of trust, the terms and conditions, the law of the trust, the Torah of the trust, which came from who? It came from the Creator. It's the same exact thing. Nothing can obstruct that. So for those that read Scripture, does the Father not promise His protection to those who follow His commandments and His statutes and His ordinances? It's the same exact thing. Article 1, Section 10 provides is a security of that right. It's a security of that right, if that makes sense. How do I put this? When you create it, when the grantor of a trust creates the trust and he makes that declaration of trust, those rights and those terms and those conditions in that trust essentially gives that trustee the ability to do whatever they need to do. And this is why it's important for trustees to look over documents before they just sign their name to being a trustee, because you might agree to something that you have no idea. You might not have counted the cost before you got involved with that. So that's important as well. Let's continue, because Article 1, Section 10 of the Constitution, that's a big one. It's a very, very big one. I put a lot of emphasis on that. Continuing. Because the express trust is created by the exercise of the natural right to contract, which cannot be abridged, the agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws or legislation or statutes or ordinances or codes passed by any of the several state legislatures. So you created it underneath the common law, a private contract underneath the common law, so they can't use codes that were not created underneath the common law to then manage a common law, a contract of the common law, if that makes sense, unless you give them an interest or a right to do so. Let's continue. Elliott versus Freeman, because this one's really good. In Elliott versus Freeman, 220 U.S. 178, the court made it clear that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court that the trust relationship comes from under the realm of equity based upon the common law right of contract and is not subject to legislative restrictions as are corporations, your S Corps, your C Corps, your LLCs, your B Corps, etc., and other organizations created by legislative authority, 501c3s, etc. To clarify the equity and common law distinctions, the basis for express trust under the common law in this instance is not that such organizations are creatures of the common law, as distinguished from equity, but that they are created under the common law of contracts and do not depend upon any statute. So to boil this down, it all boils down to two different sides of the coin: public versus private. If you're not new to trust, if you're privy, you've already begun to do research or you have an understanding about it. When we're talking about public, we're talking about statute, we're talking about Congress, we're talking about code, we're talking about, Social Security, we're talking about UCC, we're talking about a bunch of different things. When we're talking about private, when we're talking about private, we're talking about private express trust. We're talking about constitutional rights, as opposed to privileges and benefits that have the appearance of rights but are not, which can be stripped away. Rights cannot be stripped away. You can contract them away, which a lot of people are doing nowadays and don't realize, but they cannot be stripped away. That is what the Constitution is for, to hold people accountable that try to strip those rights away. I'll cover more on public versus private as it comes to me, but that is one of the most important things. And if you type in public versus private in your YouTube, you will find a lot of good resources. I don't know. There's a lot of people out there. Understand contract law. USFL is a great one. A lot of different resources that you can search in regards to that. So continuing. Now, the question is whether the parties to the contract are truly acting in their own right, sui juris, of their pure, unadulterated common law natural rights. Because if the parties import or associate, like I said, benefits or privileges which grant an outside party, a government entity, a vested interest in the proposed contract, then the contract has acquired a third-party overseer intervener. There's a footnote. I'm going to make sure I read it. 14 says, the republic is the house that no one lives in. Oh, man. Like, that should tell you enough. When we talk about public versus private, the democracy is the public. Sorry. The democracy is the public. The republic is the private. I'll say that again. The democracy is the public. The republic is the private. All of your private rights are underneath the republic, but nobody lives in that house. This is why this is titled the way that it is, because a lot of people don't realize how things are operating in our commercial realm right now. We've got about 15 minutes, making some good time right now. So let's continue. Declaration of the Express Trust. The Declaration of Trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration. Meaning, you don't have to have all these fancy words, but this is important. So long as the words used make clear the settlers or grantors or creators' intent to create the trust or confer a benefit of some sort that will be best carried out in the form of a trust. Basically, your declaration of trust needs to be structured in a way that clearly states what it's doing. No ambiguity, no cloudiness, nothing opaque, nothing unclear, nothing confusing. Make it as concise and well-rounded as you possibly can. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be and often is formed out of a simple agreement or even a will. Footnote 17, Underhill on Trust. I'm not going to read that right now. But with an express trust, the declaration has been preferred since the beginnings of trust under the common law of England, which otherwise shunned fictions of law. I'll say that again. But with an express trust, the declaration has been preferred since the beginning of trust under the common law of England, which otherwise shunned fictions of law. When we talk about fictions of law, we're talking about legislative creatures, LLCs, corporations, of the like. And as you guys know, or should know, the United States of America is functioning underneath common law of England. But let's continue. This is where careful attention to detail is most crucial, because in order to properly construe the intent of the settler, the objects, property, and manner in which all is to be carried out must be set forth in an unambiguous, precise language so as to particularly create the express trust. And where the intent of the settler is unclear, listen up, this is very important. Under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid, depending on the degree of ambiguity. However, when all is done properly, obviously, there can be no lawful impairment of the obligations of contract because of Article 1, Section 10. So basically what that's saying is, make your contract clear. Otherwise, someone can apply to a court of equity, or if you entangle yourself and or whatever it may be, and someone goes snooping around, even though no one should really expose or be able to expose a private express trust unless you're being somewhat careless about it. But even then, they have to still, we'll talk about this, like they should never be able to get to you. There's so much protection and limited liability offered through the private express trust. It's unbelievable, because it's all about, it boils down, at the end we'll see, is jurisdiction at the end of this series. Probably 5 videos away, maybe 4, I don't know. I lost the point that I was going to talk about. Where is it? Let's see if it comes back to me. But yeah, like if it's unclear, let's say the trustee doesn't know, or the beneficiary thinks you're doing something wrong because the terms of the declaration are unclear. Well, guess what? that beneficiary or trustee can apply to a court of equity for interpretation. And I would like to not take my chances going there. If you can stay out of court, stay out of court. You know, a lot of people who are on this so-called sovereign citizen movement, which is frustrating because there is no such thing, and people don't even entail what actually being sovereign is. They like to go and fight battles and do protests and do all these other things when, quite frankly, you're just wasting your time. You're asking a protest. You're asking for permission. I'm going on a tangent here. Apologies, but you're asking for. You're basically arguing and complaining for something you already inherently have, but you don't actually have it because you're operating a particular status. Let's continue. Footnotes 18, 19. So yeah, let's read it. No lawful impairment of the obligation of contract. Article 1, Section 10, Clause 10, I believe. No state shall pass any law impairing the obligation of contracts. That's in the Constitution because, again, like I said earlier, that is derived from our Creator. Our Creator gave us His law, love Him with all our heart, with all our mind, with our soul, love our neighbor as ourselves, and then other laws that fall underneath those for the appropriate administration of the property He's given to us for the beneficiaries that came after. It really is simple when you boil it down to that, because all law all natural law in its inherent form is spiritual law when it comes from our Creator. Let's continue. Moreover, the Declaration by its terms and provisions serves to establish the entire contractual arrangement, including the identities and positions of the parties, the trust's name, make it bigger, jurisdiction and situs, and all particulars of administration, all of which the courts of equity will fully support by the principle that equity compels performance. That is a maxim of law. And here you go. Equity compels performance. Clues versus Jameson. You see all these case laws, all these, most of these are Supreme Court rulings. Here you go, U.S. Like you see, like this is big stuff, guys. This is established. This is not some mumbo jumbo. This is truth, and this is real. You have power to operate like this, but you have to get an understanding, and that's why I'm here trying to break it down to help myself understand, but help you understand at its finest level how powerful this is and what you can actually do with it. The ultimate result is the creation of a bona fide legal entity. See Burnett versus Smith. I don't want to cover that right now. With its own separate and distinct juridical personality. Let's look up the word juridical. I haven't looked the word up yet. Let's look at it. Oh, which one do we want? Juridical person. Entity as a firm that is not a single natural person, meaning as a human being, not a man, authorized by law with duties and rights. Recognized as a legal authority having a distinct entity, a legal personality, also known as a artificial person, juridical entity, juristic person, or legal person, also referred to body corporate. These later parts don't necessarily apply to when we're talking about trust. It is a person, but it's not an artificial one. And if I'm speaking on that, attest that to my ignorance and my lack of knowledge, and not to the private express trust. But continuing. And to function as a distinct juridical personality with standing to sue and be sued, and to function as a person in commerce by and through its trustees. The term natural person has been applied to express trust by courts of equity because of its administration being carried out by men acting as natural persons. Here we go. This is the good stuff. I'm gonna finish this paragraph, and I'm gonna read all of this because I think we might have gotten to our first stopping point. Yeah, we're perfect. This is perfect. Because this is some big stuff here. The term natural person has been applied to express trust under this application, the trust right of contract is alienable or alienable. Go look up what a lien is. Let's just look it up. You know what? We're here. Let's do it. Let's do it, right? I just pressed a random button, sorry. Lean, lean, lean. I just want lean. You've got to be kidding me. I just want lean, my brother. You're not going to give that to me. Okay, I'm not going to spend too much time. I don't want to paraphrase it, so I'm going to keep going. Whereas its creator's natural right of contract obviously is not. So the person, the grantor of the express trust is not alienable or inalienable or unalienable, if that makes sense. Continuing. The express trust nevertheless possesses, inter alia, the right of all enjoyments stemming from the contracts into which it enters, as well as all the obligations imposed under such contracts. The express trust possesses the ability to hold own property, engage in business transactions, and incur liabilities, including tax liabilities, if it so pleases, as well as assume creditorship, including secure party status, like any other legal person. Again, this is not legal advice. This is for entertainment and educational purposes only. So let's go back up, because we had a footnote here talking about persons. And perk your ears up, because this is the good stuff right here. And this is going to help make things clear as to how our society is the way it is and why things are the way they are. So a generally unknown fact is that there are several types of citizens now existing in America. Let's see, let me just, you know what? We're here, right? Let's type in citizen. See if they give us something here. In general, a member of a free city or juro society, possessing all the rights and privileges which can be enjoyed by any person under its constitution and government, and subject to the corresponding duties. On your face, you might look at that like, okay, what are you saying here? Rights, privileges, private, public, private, public, private, public. That is a very important distinction here. Under its constitution and government, private, public, private, public. Government gives privileges. Constitution protects rights. And you're subject to the corresponding duties depending on which one you fall underneath. Let's keep reading. The trustees of an express trust may seek protection under the Constitution as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment, which we will discuss in a later section. Well, we're going to read it right now. We're going to read that right now, because this is good stuff. It clears things up. I don't need to explain. I just want to read it. Okay. Sorry. I want to read it myself. Sorry. Do, 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 do. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of those laws. Born or naturalized in the United States. We're not going to go too far into it, but I'm going to explain it to you. So basically, what that is saying is, the United States, you go look it up on Dun & Bradstreet. It's a corporation, or it's a Roman civil enclave, et cetera, et cetera. There's so many different ways to look at it. But let's just say it's a corporation for now. operating underneath a different form of law. There is the United States, public, United States of America, republic, private. Let's continue. I just wanted to show you that as a precursor to what we're about to read. Because state citizens are not underneath the United States. They are underneath the United States of America Republic. Because the Republic of the States, the Union of the States, form that. And the private. Each state constitution is a trust document, private common law document. It's the state of Mississippi that creates a public version of all of these things. Let's continue. However, it should also be noted of all citizenship, 14th Amendment or otherwise, that jurisdiction over natural and artificial persons is distinguished out of a fundamental difference. The reason why this is because, let me keep going. This stems, surprisingly, from the operation of in rem jurisdiction, which underlies all civil law. In rem jurisdiction is things. Let's keep going. Though all courts are familiar with the action of personam against persons, it is the action in rem against things which, though practiced only in maritime law, stealthily operates in every civil and criminal court. This principle is one of the least understood in its entirety. In rem jurisdiction over a man or woman can only exist if the man or woman is a slave, or property, or res, in which case his or her disposition at law is no different than if he or her were a horse or other goods. I want to find it. I'm not going to be able to find it. I want to be able to show you guys this. But essentially, as a United States citizen, you are a subject or chattel, which means you are a slave or you are property. That is not my distinction. That is what the Supreme Court of the United States has ruled. I don't know. I want to be able to find this, but it's embarrassing. It's very embarrassing. But let's continue. See the Zong Gregson versus Gilbert. In nature, in rem jurisdiction over things, is exercised over men and women by their creator exclusively. So going back to our Father, He created us. To Him, like, we're special things, but we are things to Him because He created us. Likewise, governments can only have control over things that they created, as we're about to see in this next part. Governments can therefore gain only a fictional in rem jurisdiction over men by creating various legal devices, personas, and we're going to go in depth about that, for those men to assume limited control of citizen, taxpayer, driver, etc. Since the device is a legal fiction, a falsehood made true by force of law, this persona is in fact a legal object or res, thing. Just as in theater, the person is separate from the man or woman playing the part. Therefore, there may be artificial persons, but not artificial men. Natural persons, but not natural men. Let's keep going. The word person defined, Gaia says, de juris divisione, the divisions of law, immediately preceding his division of the law. Then follows, de conditione hominum, meaning the condition or status of men. Status is a very important word to understand. I just want status. Come on. The status of a person is his legal position or condition. Thus, when we say that the status of a woman after a decree nisi for the dissolution of her marriage with her husband has been made, but before it has been made absolute, is that of a married woman, we mean that she has the same legal rights, liabilities, and disabilities as an ordinary married woman. The term is chiefly applied to persons under disability, or persons who have some peculiar condition which prevents the general law from applying to them in the same way as it does to ordinary persons. There are certain rights and duties with certain capacities and incapacities to take rights and incur duties, by which persons, as subjects of law, are variously determined to certain classes. Oh my gosh. What? The rights, duties, capacities, or incapacities which determine a given person to any of these classes constitute a condition or status with which the person is invested. Long story short, there are different classes of citizens. And you should understand that. Especially, you should understand that in the time that we were in. Let's continue. In the Institutes de Jura Personarum, precedes the expression, all our civil law relates either to persons or to things or to actions. The words persona and personae did not have the meaning in the Roman which attaches to homo, the individual, or a man in the English. It had peculiar reference to artificial beings and the condition of status of individuals, meaning person was never meant to mean man or woman. It was meant to be talking about an artificial person. It was the English language that adopted that to essentially mean that person, that man, that person, that woman, that person, you know what I mean, that boy, that girl. Let's continue. The word person, in its primitive and natural sense, signifies the mask with which actors who played dramatic pieces in Rome and Greece covered their heads. This is important to realize because when we talk about the basis off of what our law is founded on, it's Roman civil law. And you see where all of this came from, the etymology of the words. Whenever you're researching something, always dig deep into the etymology. It's going to give you a more clear interpretation. Let's continue. These pieces were played in public places and afterwards in such vast amphitheaters that it was impossible for a man to make himself heard by all the spectators and later by all judges. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part he was to play, and it was so contrived that the opening for the emission of his voice made the sounds clearer and more resounding. Vox pronabat. When the name persona was given to the instrument or mask which facilitated the resounding of his legal voice. Persona was given to the instrument or mask which facilitated his actions. Let's keep going. The name persona was afterwards applied to the part itself which the actor had undertaken to play, because the face of the mask was adopted to the age and character of him who was considered as speaking, and sometimes it was his own portrait. It is in this last sense of personage, his own portrait, or the part of which the individual plays, that the word persona is employed in jurisprudence. So this last part right here where it says his own portrait was used as his character, for his character. It's used in American law. Jurisprudence. Let me just pull that word up for you if it's going to give me a definition. Don't make fun of my typing. I'm only typing with one finger. Jurisprudence, the philosophy or law or the science which treats of the principles of positive law and legal relations. The term is wrongly applied to actual systems of law or to current views of law or to suggestions for its amendment, but is the name of a science. The science is a formal or analytical rather than a material one. It is the science of actual or positive law. It is wrongly divided into general and particular, or into philosophical and historical, and may therefore be deigned as the formal science of positive law. I'm not going to read all that, but it's giving you an understanding, because this is the foundation of law in the United States. In opposition to the word man, homo, person versus homo, public versus private. When we speak of a person, we only consider the state of a man, the part he plays in society abstractly without considering the individual or the flesh and blood. First Bouvier's definition. We're almost there. I'm going to close with this. The logic follows that if a man plays no part in a society, or he doesn't assume the person, or there's other words for that, then he has no personal attachment or obligation thereto. So if I'm not playing a person underneath the commercial system, I don't have an obligation. I'm not accepting benefits. I'm not accepting privileges. That means I'm not underneath the jurisdiction. Let's keep going. The trustees under a declaration of express trust are only persons in the private sense, because he is only a person once he has accepted the role offered to him by the grantor settler. So what that means is essentially when I accept the trustee position from the grantor, from the creator, I am underneath the jurisdiction of that trust document. And since that trust document was made underneath the common law, I have assumed all common law rights and protections. Let's keep going. Private persons may also pursue constitutional protections, like I was just saying, as natural persons, citizens within the meaning of Article 4, Section 2 of the Constitution, and may thereby claim entitlement to all the privileges and immunities of same. See generally Paul versus Virginia. Even though in today's economic situation the term citizen is presumed to signify the 14th Amendment citizen, the term cannot be applied to express trust when administered properly, because they were not born in the United States. They were born under the United States of America Republic. Come on now. Stay with me. Finishing up. In contrast, corporations, as artificial persons, are citizens of the United States within the meaning of the 14th Amendment per Santa Clara County versus Southern Pacific Railroad Company. Guys, they're telling you right here. This is case law. This is not man's opinion. This is not my opinion. This isn't legal advice or anything. They're just telling you. Let's see. 25. Let's finish with 25 and then we're done. Man's right of contract is considered so fundamental that even under Roman civil law, in its system of domestic slavery, all men, citizen or not, with the exception of slaves, the only non-persons, retain this fundamental right, ius gentium. It is understood to derive from a man's creator, and therefore is unalienable, even with his own consent waiver. Man's right of contract, logically, is held by him in trust to his creator as property which has been settled upon him, and thus can never be contracted away, because such would invalidate the original contract itself. Now, that is up for debate, but this is what I was explaining to you earlier about how our right to contract is derived directly from the Father. We're gonna wrap up with that, because I think we did a really good job of breaking this down. Next time we hop into this, we're going to be talking about trust corpus, which is all it is a fancy word for the body of the trust. But if you have any questions, if you liked it, please give a like, subscribe, share, all of that stuff. We're looking forward to keep going deeper and deeper of the subject of the private express trust with you guys. This is not legal advice. This is for entertainment and satirical and educational purposes only. Peace to you all.